Just 1 second. Yes. Morning. This is interpreter. Navruza, please give me the panel for interpretation, please. Thank you.
Yes, sure.
Okay, good morning, everybody, to this first event of the fourth day of the UzAW Arbitration Week. I'm looking forward very much to this event, and I hope all of you are as well, whether you're joining from Tashkent or from online in different parts of the world. Good morning, good afternoon, good evening to you, wherever you are. This morning's event is Force Majeure, Hardship, and the Pandemic Fuel Disputes. We have with us today four very distinguished panelists and experts on the issues of force majeure and hardship. And I would like to start with introductions. First up, we have Dr. Harold Sipple. And Dr. Harold Sipple is the founder of Sipple.legal, which is an international boutique firm with a special focus on East Asia and the ASEAN region. He has spent the major part of his career in East Asia and speaks several Asian languages. He's the founder of forcemajeure.asia, which is the world's first website solely dedicated to legal and practical matters of force majeure. Next up, we have Mr. Askar Konisbayev, and he is a partner at Grata International in Kazakhstan. He represents clients on a wide range of issues in commercial litigation, international and domestic arbitration. He has conducted matters concerning commercial and corporate disputes concerning property rights, real estate, construction, shareholders' rights, breach of contract, and many other regulatory issues. He's also an arbitrator at the Atamekan Arbitration Center in Kazakhstan. Third, we have Mr. Ilarion Ten, and he is a senior associate at Central Law Firm in Kyrgyzstan. He joined Central Law Firm in 2014, and he has experience in the microfinance sector in corporate and commercial law, and he's as well as in corporate and intellectual property issues. He has advised many different clients in offshore and free trade zones, legal support of businesses, etc. And finally, we have, last but not least, we have Ms. Diora Zieva, and she's a counsel at Denton's New York office. She has been involved in over 24 international arbitration proceedings representing states, state-owned entities, and corporate clients in arbitrations, both investor, state, and commercial. The sectors that she has worked with concern energy, oil and gas, mining, telecommunications, construction, aerospace, and more. She was part of the teams that successfully represented the states of Turkmenistan and Kazakhstan in a series of investor-state arbitrations. She's a graduate of Harvard Law School and of Uzbekistan's University of World Economy and Diplomacy. I'm very pleased to, this morning to have with us these distinguished panelists, and all of these panelists are part of writing a book, which I understand is now in fact finished and available. This book is called Force Majeure and Hardship in the Central Asia Region. I believe someone from the TIAC team perhaps may be able to, during the course of this webinar, share a link to this book. And if anyone is interested, you are most welcome to take a look. So now moving on to the topics for today's discussion, it's a force majeure, hardship, and the pandemic fuel disputes. I'll start with just a very brief introduction so that we can move and give our time to the panelists. Force majeure, as we all know, has been an issue that has been of great interest around the world since COVID came to the world last year. And it generally refers to a clause in a contract which provides for certain circumstances to occur upon the occurrence of certain events that render the performance of a contract difficult or impossible. And usually the results could be termination or the exemption of liabilities. And it's not just a clause. In common law jurisdictions, that's how it usually operates. But in civil law jurisdictions such as China, where I'm from, I'm from Singapore, but I'm based in China with a Zonglun law firm. The doctrine of force majeure also operates as a civil law concept by statute, and this also may have impact on how the concept should be understood and applied in practice. For hardship also refers generally to a clause that can be set out in a contract. It addresses circumstances where unforeseen events fundamentally alter the equilibrium of a contract, resulting in performance being excessively burdensome for a party. And in such circumstances, a mechanism could perhaps be implemented to result in the modification or adaptation of a contract to render continued performance possible and equitable. In the PLC where I'm based, there is a concept that is similar, known as change of circumstances, and in fact I've been involved in some cases involving both force majeure and change of circumstances over here. But these are I don't want to take too much time, and so let us begin with our roundtable discussion, and where we can discuss these issues in greater detail. And to kick off our roundtable discussion, I'd like to first throw up a question to our panelists, our distinguished panelists here with us today, concerning the scope and definition of force majeure and hardship. Like I mentioned, there's a difference in common law legal systems and civil law legal systems. It can be a contractual mechanism or it can be a statutory mechanism. And I'd like to throw up the first question to the panelists as to what are some of these implications arising from this for businesses.
If I may jump in here, Charles, thank you for the question. And thank you once again for inviting me to take part in this important event. Special thanks to Tashkent International Arbitration Center and Diana Baizakova. And the question really is indeed important for framing the discussion that we have today, because in terms of implications for businesses that may affect the ability to invoke force majeure in the absence of contractual terms governing the issue. Force majeure, as we know, is a contractual concept that relieves parties in certain instances to a contract from performing certain contractual obligations if specified events or, let's say, conditions called force majeure events occur. Because there is no common law right of force majeure, a contract most of the time must contain a force majeure clause in order for a party to actually invoke this concept. At the same time, as you have already pointed out, Charles, a force majeure clause in civil law jurisdiction, it can be invoked by the application of law, even if the contract is silent on force majeure. So this means that businesses should be mindful of whether the applicable law contains provisions on force majeure or, for instance, similar legal concepts. And this is particularly important for clients in Central Asia, in this instance, where the national laws include statutory provisions on force majeure or similar concepts, for example, circumstances of irresistible force, like the one, for instance, in Turkmenistan, the chapter that I'm writing about, where the Article 410 of the Civil Code of Turkmenistan discusses this issue. But in international transaction, the business regularly subject their contracts to, for instance, New York or English law that does not necessarily regulate force majeure. And in such circumstances, businesses should carefully draft the force majeure clause in order to define its scope and provide for a mechanism, for a specific mechanism to invoke it.
Thanks very much, Diara. So on this topic of drafting, this is it's a perfect segue to the next question that I shall pose into the panelists. And as we know, force majeure clauses are at the core of force majeure disputes. When should parties include force majeure clauses in their contracts, and what considerations should they bear in mind during the course of this process?
Maybe I can take this question, Charles.
Thanks very much.
I'm giving an answer that all lawyers do. It depends. It depends on the circumstances, on the parties involved, and what generally happens. I think Diora already pointed out something that's very important. Under the laws of some countries, usually civil law countries, force majeure is a matter of statutory law, while in common law countries, it is typically not. So this would be one consideration. And of course, you cannot give a general rule that applies universally because it really depends on who the parties are and what law they intend to apply. Now, my own advice to parties when they ask me about the drafting of a force majeure clause, it's more in the lines of think about more of what you can do wrong, because if you stick to a boilerplate clause, a template clause, you cannot really do much wrong because this clause will be enforceable. If you start copying from here and there, if you start mixing two clauses, it's going to be a nightmare. And possibly when there is an instance of force majeure, you will enter into a very big argument whether this instance actually exists according to the clause. And this is exactly what you do not want, because the reason we have force majeure clauses in the first place is to ensure that when the unforeseen happens, we have a rule on how to act. But if we need to argue on what to do, then it's a complete nightmare. So my really number one advice when it comes to drafting would be stick to boilerplate clauses and do not mix. And in the interest of time, I'll limit myself to this. Thank you.
Thanks very much, Harold, for sharing. Is there anyone else who would like to share?
Thank you, Harold. I just wanted to add a little bit information about force majeure clauses in Kyrgyzstan, and Kyrgyzstan is a country that uses a civil law system, and as our speakers mentioned earlier, it have a statutory requirements for force majeure. However, in Kyrgyzstan, it has only a general concept of force majeure. And in accordance with civil code, a person who has not fulfilled the improperly fulfilled the obligation under the contract is liable if he does not prove that the proper performance was impossible due to the force majeure. So this is the general concept of force majeure, statutory force majeure in Kyrgyzstan. In that case, also the civil code provides the opportunity for the parties to include other conditions for exemption from liability in the contract. So in Kyrgyzstan, the force majeure clauses should be drafted with keeping in mind that it's regulated by statutory provisions and the contracts and the provisions which party will include in the contract. So boost the ability of a party to claim release from liability in Kyrgyz Republic in the event of force majeure depends on the terms of a contract and in particular of force majeure.
Thanks very much, Ilarian. So those are some very interesting observations concerning the drafting of a force majeure clause. And now, just thinking about, I would like to have a discussion for the benefit of the audience concerning how a force majeure dispute works. And often, when a force majeure event occurs, the first thing that would happen is that the party would try to invoke the force majeure clause, and in order to do so, there would usually be a critical first step which is required, which is the giving of force majeure notice. And on this issue, may I invite the panelists to share lessons from their experiences concerning the notice requirement of force majeure and how businesses can ensure that they give good and effective force majeure notices.
Let me start from our experience in Kyrgyzstan. First of all, in Kyrgyzstan, in contracts, usually the parties include force majeure provisions. However, in order to implement the force majeure according to the contract, first step is to send the notice on the event of force majeure to the counterparty. These steps are not regulated statutory, it's purely regulated by the contract. However, in contracts, it's regularly included that the notice, written notice should be sent in case of force majeure. The notice should be sent to the counterparty in the reasonable time, in case if it's not stipulated by the contract. The most important information which should be included into the note, from our experience, is that the notification should include information about the situation, how it affects the contract, and for what period of time these negative effects may continue, and prevent the party to not to fulfill its obligations under the contract. Also important is how you send the note. From the experience, we can say it always should be written note. It should be written note. In case if it's sent by the mail, it should be sent by the official mail with notification on delivery, or by other ways which may be confirmed that the notification was sent and received by the recipient. In addition, if we recommend to, since it's force majeure, general concept of force majeure regulated by our civil code, we recommend to include the reference to the Article 356 of the Civil Code of the Kyrgyz Republic, which regulates the force majeure, and to attach to the notification any documents that may confirm the force majeure situation. It could be the certificate from Chamber of Commerce, maybe some legal acts of government which, for example, implemented the emergency situation in the country, how it was during the pandemic in Kyrgyzstan. And this is, I think, this covers the main steps for notification in Kyrgyz Republic.
Thanks very much, Ilarion. I think a lot of the concepts that you have shared are not just applicable in your jurisdiction, but perhaps across the world as well. In the interest of time, shall we now talk about what happens after a force majeure notice is issued, and when a party invoking force majeure issues a notice, with the consideration of all the points that have been shared by Ilarion, what can happen is that the other party would receive it, and then it may be that the other party may not agree with its contents, and in fact the other party may wish the contract to be performed, and in order to achieve this, they would usually want to issue an objection. And pursuant to this objection, the matter may subsequently go to litigation or arbitration. And there are many, many different grounds of potential objections to force majeure notices. And some of these grounds include issues from such as causation, foreseeability, invalid notices, and others. I'd like to first talk about causation. And can I ask the panelists, what are some of the causation issues that could possibly arise?
If I could jump in here, Charles, I think the main issue here is whether the force majeure event, when it comes to causation, was the sole reason for the party's non-compliance with contractual obligations. Although the answer oftentimes is largely based on the wording of the force majeure clause, we can deduce some patterns from court practice. So, for example, if we take one of the famous cases in the England and Wales Court of Appeals called Limbangan, that court ruled that if a clause does not contemplate the termination of the contract as a consequence of the force majeure event, which is a contractual frustration clause, and instead only excuses liability for a failure to perform, which was an exception clause, a but-for test of causation will apply. So in other words, a party may, would have had to perform the contract absent the force majeure event. So the force majeure clause at issue in that case excluded liability for failure to perform the obligation that resulted from the force majeure event that sort of, as court put it, directly affected their performance. And what's interesting is that after having analyzed the facts of that case, the Court of Appeals found that the party was not going to perform its obligations despite the force majeure event because it stopped performing prior to the event and was not able or willing to continue after the force majeure event occurred. So at the same time, when the contract provides for termination as a result of a force majeure event, the but-for causation test does not apply in the words of the court. And we saw a similar reasoning in 2018, which was encountered in another case, which was called the Sidril Ghana operation versus Tulo Ghana, where a defendant claimed force majeure under the contract for the hire of an oil rig. In that case, and I think it's an interesting case to point out, the government of Ghana imposed a drilling moratorium, and the defendant claimed this constituted a force majeure event that prevented the company from undertaking drilling operations. However, the High Court of England and Wales found that the reason why the defendant did not proceed with drilling operation was because the government had not approved its drilling plan. So the court ruled that this failure did not amount to force majeure events. So the moratorium could not have affected the companies because the government did not approve its drilling plan. So these two cases from the common law jurisdiction, I think, provide an interesting context for this issue.
That's extremely fascinating. This but-for test for causation for force majeure, it's a big issue. I believe it was quite heavily debated in those cases, and I wonder if anyone else has anything to add on this.
Maybe I may jump in again, Charles. I just like to put in very practical terms what Diora has brilliantly described in the case law. In practice, what you will see, especially if you are with a company and not a law firm, is that especially these days, a lot of companies are going to say, oh, sorry, we cannot deliver. It's a case of force majeure. Because these days, everybody speaks about force majeure. And it may be correct. It may be that your government, be it at the federal level, at the regional, at the local level, any authorities imposed any restrictions whatsoever. That may well be the case. But as a company that's faced with a notice of force majeure, you should by all means always demand full information so that you are in a position to fully assess if the failure to perform or the excuse already in advance, if it is just an excuse, as we say, or if it's really an excuse under the terms of the contract that excuses from performance. So it's of utmost importance that you really have a full understanding of the entire situation and don't merely rely on what your contract partner tells you.
Entirely, that's like absolutely fascinating, and we could imagine, of course, that that parties, some parties, unscrupulous parties, may have their own reasons for not performing a contract, and then they would rely on something that occurs in the news, and they would say, "Oh, there's a force majeure, and therefore I'm off the hook."
But it's sorry, Charles, if I may just add one really minor point. I've seen it in practice now 3 times that there wasn't even any bad intention on the side of the company. They really did think that it was automatically a case of force majeure because they had seen it so often. And then they stopped working because it was just convenient for them.
Indeed, indeed. This is it's quite a common issue in practice, and we can often see that in notices and objections to notices of force majeure, we would have the other party demanding a clear explanation as to how, the alleged force majeure event caused the interruption of performance of a particular contractual obligation. Let's now talk about the issue of foreseeability. Is it possible sometimes for a party to claim that an alleged force majeure event was foreseeable? And what are some of your experiences in this regard?
If I may jump in here, I think the short answer to your question, Charles, is yes, it is possible. And again, turning sort of to the case law, for example, in one of the exit cases, which is called Autopista de Venezuela, the respondent argued that civil unrest provoked by prospective road toll increase was unforeseeable, and therefore accordingly constituted a force majeure event. So in that case, the claimant actually objected to this, stating that civil unrest was foreseeable. So the tribunal, after analyzing for a certain period of time, sided with claimant by arguing that actually Venezuela did not convince the tribunal that the possibility of civil unrest could not be foreseeable under the circumstances at the time of negotiation of the concession agreement. So timing became important. And speaking about the COVID-19 pandemic, which we all lived through, in an interim order from May of 2020, the president of the Paris Commercial Court found that the spread of the virus is clearly external to the parties, and that it is irresistible and that it is unforeseeable, as sort of evidenced by the suddenness and extent of its appearance. So the condition for force majeure, in the words of that court, as defined by the contract binding the parties in that particular case that the Paris Commercial Court looked at, were, as it would put, manifestly met. So the decision is one of the very first ones, at least in France, that qualified in commercial terms the COVID-19 pandemic as a force majeure. So in the same vein, I think we can also consider cases that predate the circumstances that we live in now, to some extent, but also in the context of, let's say, the United States, the jurisdiction where I practice. We can consider the case like the Union Fenosa Gas versus Egypt, where Egypt asked the United States court to stay the enforcement of the exit award pending annulment, and the court looked into consideration of the unprecedented global pandemic in granting the stay. So I think, turning specifically to the practice of Turkmenistan, the chapter that I contributed to, it is known that as a result of the anti-COVID-19 measures in May 2020, Turkmen Post, a national postal operator in Turkmenistan, declared a force majeure event beginning of March 18, 2020, which suspended all inbound and outbound and transit mail until sort of further notice. So that's an example that was later closed in January of 2021.
Fascinating cases. Does anyone else have anything to add on the issue of foreseeability?
Maybe I once again add something very practical. You can see between Diora and me who's the brilliant lawyer and who's the basic guy, because she conveys all the case law so brilliantly, and I just try to put things into very basic terms. I again want to go back and elaborate on what Diora said. When we speak about foreseeability, in my experience, what's also really important is that we look at the particular circumstances. And once again, my general answer with respect to foreseeability would be, it depends. because the circumstances are different every single time. Think about the beginning of the COVID-19 pandemic. Initially, it came to a surprise to, I believe, pretty much all of us, and it called pretty much everyone off guard, including government measures. But 1 year into the pandemic, can you still say that it comes as a huge surprise if a government closes down a harbor? I'm not taking any position here. I'm just raising it to you. It depends, and it's trickier. At the same time, if you have, if you're in East Asia, where I'm based, and you know that there is the rainy season when it really rains heavily, arguably, in general, rain is not, or heavy rain, I should say, is not considered a force majeure event because it's foreseeable. You know that around this time of the year, approximately, there is going to be rain. But what if on one day, this rainfall is extraordinarily strong? Then even though it was foreseeable that there would be heavy rains, it was possibly not foreseeable that there were extraordinarily, that's a difficult word, strong rains. And as a result, the rainfall, which in theory was foreseeable, suddenly is not foreseeable anymore. So I go back to what I emphasized before, that the particular circumstances really matter. And for you as a company that's involved, with a force majeure claim from the other side, it's really important that you are fully aware of all those circumstances that matter, because only then you can safeguard your rights.
Just want to add a very quick a note on this issue of foreseeability, and that's if there is a contractual force majeure clause which lists out a certain list of force majeure events, for example, riots, or if it says, you know, it could potentially be argued that you know, like, being listed in the clause shows that the parties had foreseen that particular risk as being something that could impact upon the performance of the contract. But then again, we have that issue of the extent of the possible you know, impact or the event, as Harold has talked about, for example, concerning rainfall. Now, let's talk about the issue of what amounts to force majeure events. And as we know, a force majeure clause would usually set out a list of events, 5, 6, 7 events, you know, riots, pandemic, government actions, you know, strike, etc. And what happens if an alleged force majeure event is not expressly within the list of events defined in a force majeure clause? And in such a situation, how should parties deal with this?
Charles, let me chip in here. In accordance with the civil law system, where in comparison with the common law system, where the force majeure regulated purely by the contract, in civil law system countries, you should keep in mind that in civil law system countries, the force majeure also may be regulated by imperative norms of the civil code. So even force majeure event is not listed in the contract, it may be implemented in accordance with the legislation. For example, in Kyrgyzstan, not force majeure event is a violation of it's not considered a force majeure event in case of violation of obligations by a counterparty, in case of absence of market of the goods necessary for execution, absence of necessary funds from the debtor, and not force majeure circumstances. So this is the imperative norm of the civil code, and in case, even if it's written in the contract, you cannot reference to these provisions in order to claim the force majeure event. So so in our case, it's that not force majeure events are regulated by the civil code and not purely by the contract. So
That's a very
okay.
No, please,
force-
please go on. Yep.
Force majeure usually requires the affected party ability to perform its obligation under the contract, or is prevented, impeded, or hindered otherwise in the event that affected party must look at reasonable steps to seek to avoid or mitigate the event or consequences.
Well, I was very much interested in that that statement that you made, that in your jurisdiction, the absence of a market is expressly stated to be not a force majeure event, and the absence of a market relates to economic impact of non-performance or performing an obligation. And sometimes in practice, we can see that a party may claim force majeure when something happens in the world which makes its performance more expensive. Like, for example, oh, there's no more market, they can't sell the products anymore, therefore, like, should we still continue to supply? However, performance is still in fact possible. And in this sort of situation where there is only a financial impact but performance is still possible, is this a force majeure?
I may jump in, Charles here. Thank you for the question. As I understand, yes, from the question, maybe I should start from a general point, which is Kazakh statutory requirement sets a very high standard for force majeure, which in Kazakhstan is called insuperable force, as provided for in Article 359(2) of Kazakhstan Civil Code. This requires parties seeking to invoke force majeure prove that proper performance was impossible due to insuperable force that is extraordinary and unavoidable in nature. So the language of the provision is sets very high standard. So this obviously does not include any questions of difficulty, convenience, or financial burden to perform the contract, as you said. So as from the question, we see that the performance is still possible, but it becomes costly for one of the parties. We have to keep in mind that this is a clear case where statutory requirements for force majeure are not satisfied. In this case, we should look into contractual provisions as parties stipulate in their contract. Under Kazakh law, the parties may derogate from statutory requirement for force majeure and set different requirements for exemption for liability. So obviously, from statutory point, it's not a force majeure clause, but we have to look and check whether the parties have included a hardship clause into their contract. For instance, in Kazakhstan, there is no kind of overriding principle of hardship, general principle of hardship, because of a very high standard. And this question is left to the parties to regulate themselves. But we still have some elements similar to hardship in relation to some types of contracts. For instance, in lease contract and work contracts, we have provisions where a tenant may reconsider the contract price if the conditions of use have significantly deteriorated. And the same goes to work contracts. The party may reconsider the price contract if there is a significant increase in the price due to circumstances beyond contractor's control. So there are similar provisions to hardship, but no kind of general provision or regulating general contracts. So again, in this particular point where there's a financial burden and financial impact on performance of contract, I would say that look into contractual provisions where there's a hardship clause, because under statutory requirement, it's not going to help. It's not going to amount to force majeure. Cool.
Thanks very much. Ilarion, you were about to say something. I'm sorry, it seems that you're on mute.
I'm saying it's already covered. Thank you.
Thanks very much. Oh, so in view of the insights that have been shared, for example, financial impact is at least in Kazakhstan not regarded as force majeure, but it could be something that is contractually provided for. In light of this, as well as the many other considerations in force majeure, could I ask what are some practical tips for parties on the receiving end of a force majeure claim?
If if I may, Charles, just take on what I was saying on financial impact. When you face with the problem of force majeure, I think when you are at the receiving end of a force majeure claim, you have to check whether all the elements of force majeure as provided in statutes or in a contract, if there is a force majeure clause, are satisfied. So basically, if we're talking about Kazakhstan, where I said there is a very high standard for force majeure clause, you have to check whether all elements are satisfied, such as impossibility to perform, the first one. So it's not difficulty, it's not convenience, it's impossibility. The language is very strong and clear. You have to check whether the occurrence of extraordinary and unavoidable events. Again, very strong language. And a very interesting question of causal link, of course, between impossibility to perform and the occurred events. If the events led to, or if the impossibility led to late performance or improper performance. And as you discussed earlier, notice requirement is very important as well. Sometimes if you fail to notice, you are released from relying on force majeure. So a practical tip would be check carefully contract requirements, whether they have been met, check the contractual provisions, and maybe if you receive such a claim, maybe it is it makes sense not to be very quick in conclusions, because if there is a force majeure, you as a creditor may find yourself in a similar situation towards other counterparties. So it is important to keep in mind. And but anyway, if you're dealing with a force majeure claim, you have to check the evidence, all elements that are satisfied.
Could I invite perhaps quick comments from anyone else who wishes to add, perhaps Harold?
Yes, I'd be happy to, Charles. I fully agree with everything Oskar said. He gave some excellent tips for practice. In fact, I would even suggest that you take the force majeure claim, you print it out, put it on your table, and then you take the contract and put it next to it. And then you go to the force majeure clause and you check one by one to make sure that all requirements are met, because some of these requirements are not so straightforward as others are. If you do that, then you will likely make sure that you have everything. What we must keep in mind also is, think of the practical situation. This may be something that does not impact the company as such. For instance, the Suez Canal blockade, which we had a few months ago, it's not gonna affect your office because your office is not on a ship. But if you are in a country where there's an earthquake, for instance, and your office is destroyed, then even sending a notice is going to be difficult, and we cannot expect that the notice is so elaborated. So I once again fully agree with Oskar. It's important to collect all the information and not to jump to conclusions too early, because if you do jump to conclusions too early, it could very much impact your own legal situation, because you have obligations towards your own customers, as Oskar pointed out.
Thanks very much, Harold. Now let's move the discussion to beyond the discussion of determining whether or not an event amounts to a force majeure, whether or not it's a valid declaration. Let's assume that there has been a valid declaration of force majeure, and in such a circumstance, could I ask the panelists what are the effects of this?
Let me step in here, Charles. For example, a force majeure provision typically relieves the party from what otherwise be a breach of a contract. For example, it's failure to perform an obligation due to the effects of events of force majeure. However, the party must establish the causal link between the event and the inability to perform. In case of successful application of force majeure clause, it is possible not to be held liable for to pay forfeit or penalty or fine or reimburse the losses or other obligations established by the contract, which you cannot fulfill due to the force majeure event. However, if the other party disagree, and there is in Kyrgyzstan there is only way except the negotiation is to other ways of mediation and arbitration. The question should be decided in the court.
Okay. Now, let's say the parties enter into a process where this force majeure issue is to be determined by a court. How should parties, do the panelists have any practical tips as to how the parties should manage their affairs while this process is going on?
Charles, I think that frequently, if I may here, the force majeure clause will expressly require the party to use reasonable efforts to mitigate the effects of the force majeure event. However, I think even if the clause does not expressly impose an obligation on a party to take mitigation measures, in practice, the party may still need to show that it could not mitigate the effects to demonstrate causation between a force majeure event and a non-performance of obligations. Therefore, I think if alternative modes of performance are available but have not been pursued by a party, it becomes less likely that a court will consider a party's non-performance attributable solely to the force majeure event. And I think that's a distinctive point that needs to be made.
Fascinating. So mitigation is something which arises quite often in the force majeure disputes, and the points that Daira shared are quite notable. And sometimes in practice, you would find that a force majeure event is temporary, and sometimes it's permanent. And what happens if a force majeure event is temporary? For example, like a border closure arising from COVID could last for a few months, and then after that it's lifted. How should parties deal with such situations?
Charles, let me add from my side that except for relief from the consequences of not fulfillment of the contract, the force majeure clause may include the provisions that the term of fulfillment of obligations under the contract, if it's temporary force majeure, may be postponed for the duration of such circumstances and its consequences. In that case, the contract may be prolonged for the duration of the temporary force majeure, without any fines or other negative consequences. And in addition, the force majeure clause may include the time limit for the temporary force majeure. For example, 3 months. If the force majeure will not be lifted in 3 months, the contract may be terminated.
Interesting. So, like, this is for all the listeners out there. This is quite a practical point, because in fact we could see that a lot of the disruptions to contractual performance, some of them are permanent, some of them are temporary, some of them, even though they're temporary, one cannot know while the event is still ongoing, when would it end. While for others, you could have perhaps quite a clear time horizon with which to plan. We're making good time. We have 10 minutes now. If anyone from the audience has any questions that you would like to ask the panelists, please feel free to ask them. You could add them into the chat box, or if you are, I suppose you're online, you're welcome to join in and ask directly. Please feel free. In the meantime, I shall continue with a few questions for our panelists. And I'd like to ask, since we have the benefit of 4 very experienced practitioners over here with us, let's change their roles, their hats from counsel, from lawyers to arbitrators. So assuming that the four of you are arbitrators who are tasked to decide a force majeure claim, what are some of the things that you would like to see when parties or their lawyers make their force majeure claims before you? What are some of the points that would help you in making your decision? And I'd like to throw this issue open to the floor.
If I may jump in, Charles, thank you for the question, interesting question. As an arbitrator, of course, you would expect the parties make their homework. You would expect the party relying on force majeure event, have all the evidence clearly structured under contract or law as applicable. I would pay particular attention to all the elements, as I mentioned earlier. And most important, I think, as for arbitrators, it is important to discuss the causal link between the force majeure event and the possibility to perform. This is because it is so factual based and creates a number of opportunities for litigators to kind of going around this question, this quite complicated concept. Because often it is not very clear whether there is a direct cause and effect between force majeure events and impossibility to perform. For instance, one of the examples in our court practice was territorial effect of force majeure. We have in Kazakhstan, we have decrees of sanitary doctors where they impose different restrictions in different regions. So in one case, a party was trying to invoke force majeure based on the restriction that was valid, declared in another region, in neighboring region. So obviously there is no direct link, and the party was basically trying to excuse from liability based on force majeure event in another region. This is an interesting question, and as an arbitrator in Kazakhstan, I would also see if a party has done all that he can in order to evidence the force majeure. In Kazakhstan, we have a Foreign Trade Chamber of Commerce, which is a body which entitled to certify force majeure events. So I would check if there is such certificate, but of course that certificate is not absolutely binding and doesn't have a overriding preference over other evidence. But in any case, I would check if all the evidence clearly structured and presented to arbitrators.
Very fascinating. This thing about force majeure certificates is present in the People's Republic of China, where I'm based, as well. And there's this agency over here called the CCPIT, and what it does is that it has the power to issue certificates to certify relevant facts in relation to force majeure. It could say that, oh, for example, this event occurred, and from how it works over here, these certificates can help parties in proving the existence of force majeure events, and I understand that yeah, quite a lot of these certificates have been issued, and they are often presented before arbitral tribunals to assist in their deliberations. Moving back now to this issue of what sorts of issues, what sorts of help do you wish to receive if you are an arbitrator? Could I invite someone else to jump in? Harold.
Yes, thank you, Charles. If you allow me, before I address your question, one quick comment on the certificates. I had them myself in one case, and I know from Europe, since I'm Austrian by origin, that a lot of Europeans looked at these certificates, they looked upon them very skeptically. I think this is for two reasons. The first reason is that in Europe, to the best of my knowledge, those organizations that issue such certificates do not exist. So when something is foreign, you automatically get a bit skeptical. The other reason is it was often perceived to be as a carte blanche, so to say. a permit to do whatever you want because this agency has certified that it's force majeure anyways. So I think the point that Oscar made before, that this is just an indication, but you in any event need to fully prove all circumstances, is of utmost importance, because you may be dealing with an arbitrator or also a party from a region where it's not so common to issue those certificates. To go back to your question on what I would like to see as an arbitrator, I have to be careful because early this week I was approached with a prospective appointment, so I cannot say too much. But I would like to emphasize a point that Diora has made before when it comes to how you should keep moving on with your operations, what you should or should not do. I think what we must never forget is that you have your contract and your contractual obligations, and then you have something else. And the something else, of course, also plays a role to arbitrators. No arbitrator would admit that he or she was influenced by what is just and fair, because in theory, you should decide based on the law. But if an arbitrator is in a situation where it appears that the party that claims to have been in a force majeure situation did not really make a lot of efforts to overcome the situation, I think that arbitrator would on average find it difficult, let's say more difficult, to really come to the conclusion that there is force majeure. So that's probably something that should also be kept in mind. But I see there's questions popping up now, so I'll end here. Thank you.
Thanks very much. Questions?
Those were not questions. Those were just notes of thank.
Okay. Well, it's great to see that this our discussion has apparently been of help to our audience. It's great to see the notes of thanks shared by the audience. We have just a final 3 minutes left, and I just have one final question for our panelists. And I'd like to ask, based on your experiences, what sorts of sectors do you see force majeure claims arising most often in? For example, construction, oil and gas, mining, import, export, sale of goods. And related to this, are there any practical differences in how force majeure claims and defenses should be handled across these different sectors?
Charles, now we do have a question from the audience.
Perhaps I will invite you then to address both the question that I've posed as well as this question from the audience as to what is the panel's future vision on force majeure clauses versus disruption clauses in the final 2 minutes.
Okay, thank you, but I'll be really quick so someone else also has the chance to share his or her views. The future vision on force majeure, we must not keep in mind that the majority of force majeure events are not man-made. The majority are natural disasters. And when you look at all reports out there, we know that in the future, we will have more natural catastrophes and they will be stronger. This is because of environmental damage done to this planet. So as much as force majeure is a buzzword now, in the future, it's likely not going to get any better. This is my future vision. On the types of industries that are most affected, I think it's all industries that have a lot of long-term agreements, oil and gas, raw materials, etc. Because the longer a contract, the more likely the chance of there being any issue. Thank you.
Well, thank you very much, Harold. We have taken up exactly an hour for this panel discussion. It was a brisk discussion. We covered so many topics. We covered notices, causation issues, objections to force majeure clauses, effects, and practical tips, as well as what arbitrators would like to hear. And I'd like to thank everyone for this for joining us. Oh, I see that there is another question. We have 30 seconds for someone to jump in to address this question. Post-pandemic, what preventive measures have been learned for future clauses? Could I have someone just jump in with a very quick answer? Perhaps Diora?
Well, I think the answer was largely answered by Harold. So the fear of not being too repetitive here, I think one thing that we've learned is that it is extremely important to make sure that the language of the contract and provision concerning force majeure or hardship, which we unfortunately haven't had a chance to discuss, is something that is addressed in a way that the parties actually intend to. And I think that is something that we learn more and more looking at the current disputes and moving forward, we understand that this is something that is extremely valuable. So I think for everyone, the most important thing to keep in mind is to put the wording of the contractual clause concerning force majeure exactly in a way that reflects the intention of the parties. So I think that's something that is quite important and future focused.
Thanks very much, Diora, for taking this final question from the audience. And I see that our time is up. Thank you once again to all our panelists for this very insightful discussion. We have covered so many topics in the span of a very short time of 1 hour. And to all of the participants in the audience, please feel free to be in contact with us. If you approach anyone in the TX Secretariat, I'm sure you can obtain our contacts. And I wish all of you all the very best. And for all of you who are attending the further sessions today, as well as tomorrow, and we'll see you then. So thank you very much, and bye-bye.
Thank you, Charles.
Thank you very much, Charles.
Thank you, everyone.
Thanks, everyone. Bye.
Thank you, everyone.